Hello and welcome to the Entrant. The topic for today's discussion is Article 15, which prohibits discrimination, and Article 16, which provides right to opportunity. This topic holds great importance when it comes to questions asked in competitive exams. Before delving into the subject matter, let us understand why these articles were included in the Constitution. Article 15 prohibits discrimination on the basis of religion, race, caste, sex, place of birth, or any of them. The article was included for providing equality in all spheres of life, that is, political, social, economic, and cultural, and to remove all and any disparities seen in these arenas. Article 15 expresses a particular application of the general principle of equality. It is when discrimination is based upon one of the grounds mentioned in Article 15, the reasonableness of the classification will be tested under Article 14. On the other hand, Article 16 of the Constitution clearly mentions that the state shall treat everyone equally in matters of employment. No citizen shall be discriminated on the basis of race, caste, religion, creed, descent, or place of birth in respect of any employment or office under the state. Every citizen of India can apply for government jobs. The guarantee under Article 15 and 16 is available to citizens only and not to every person, whether citizen or non-citizen, as under Article 14. Now let us look at Article 15. Article 15 prohibits discrimination. But first, we need to know what discrimination is. The word discrimination means to make an adverse distinction or to distinguish unfavorable from others. This definition has been taken from the case of Srinivas Iyer versus Saraswati Amal. It naturally flows that if a law makes discrimination on any of the grounds mentioned in Article 15, it can be declared invalid. To illustrate this, in the case of Nansok Das versus State of Uttar Pradesh, a law which provided for elections on the basis of separate electorates for members of different religious communities was held to be unconstitutional. Clause 1 of Article 15 uses the word only. This is an important word as it indicates that discrimination cannot be made on the grounds that one belongs to a particular caste, sex, religion, etc. It follows from this that discrimination on grounds other than religion, race, caste, sex, or place of birth is not prohibited. To illustrate this, in the case of P. Raghunanda Rao versus State of Odisha, it was held that the requirement of a test in regional languages for state employment does not contravene Article 15 as the test is made compulsory for all persons seeking employment. Clause 2 of Article 15 is a special application of the general prohibition contained in Article 15 Clause 1. It states that no citizen or the state can restrict or deny access to public spaces. It has to be noted that Clause 1 of Article 15 prohibits discrimination by the state, whereas Clause 2 prohibits both the state and private individuals from making any discrimination. The object of Article 15 Clause 2 is to eradicate the abuse of the Hindu social system and to herald a united nation. No law, custom, or usage could authorize any person to prevent any Harijans, depressed classes, or the like from having access to the public places mentioned in the Act. Clause 3 of Article 15 provides for special provisions for women and children. Article 15, Clause 3 is one of the two exceptions to the general rule laid down in Clauses 1 and 2 of Article 15. Women and children require special treatment on account of their very nature. Article 15, Clause 3 empowers the state thus to make special provisions for them. Under Article 42, women workers can be given special maternity relief, and a law to this effect will not infringe Article 15, Clause 1. In the case of Joseph Shine versus Union of India, the Supreme Court, in a 5-judge bench decision, held Section 497 of IPC penalizing the adultery violative of Article 14, 15 Clause 1 and 21 of the Constitution, and not beneficial legislation covered by Article 15 Clause 3 of the Constitution. In another landmark case of Salil Bali versus Union of India, where the Supreme Court, regarding the provisions of Juvenile Justice Act 2000 fixing 18 years as upper age limit for treating persons as juvenile, held it to be constitutionally valid. This was done so under the basis of Article 1 of the Convention of the Rights of the Child in 1989. India is not only a signatory to this convention but also has ratified it on 11th of December 1992. Another basis for this has been on the account of the understanding of experts of child psychology and behavioral patterns that till such an age the children in conflict with law could still be redeemed and restored to mainstream society instead of becoming hardened criminals in the future. Moving on, Clause 4 of Article 15 provides for special provisions for advancement of backward classes. It is another exception to Clauses 1 and 2 of Article 15, which was inserted by the Constitution First Amendment Act 1951. Due to the decision in State of Madras versus Champakan Dorairajan. In the case, the Madras government, by a government order, reserved seats in the state medical and engineering colleges for different communities in certain proportion on the basis of religion, race, and caste. The state government defended it for promoting social justice for all sections of people as required by Article 46. The Supreme Court held that the government order was void because it classified students on the basis of caste and religion irrespective of merit, and held that the directive principles of state policy could not override the fundamental rights. Here in the Constitution, backward classes has not been defined. However, Article 340 empowers the President to appoint a commission to investigate conditions of socially and educationally backward classes, and on the basis of the report of the commission, the President may specify as to who are to be considered as backward classes. The provisions in Clause 4 of Article 15 is only an enabling provision and does not impose any obligation on the state to take any special action under it. Thus, it merely confers a discretion to act if necessary, and a writ cannot be issued by the state to make reservation. The principle behind this article is that a preferential treatment can be given validly where socially and educationally backward classes need it. Article 15, Clause 4 is not an exception but makes a special application of the principle of reasonable classification. The class contemplated under the clause must both be socially and educationally backward. Thus, under Article 15, Clause 4, two things are to be determined. First, whether the class is socially or educationally backward, and the limit of reservation. Moving on, now we will look at Article 16. Article 16 guarantees equality of opportunity in public employment. Clauses 1 and 2 of Article 16 lay down the general rule of equality of opportunity or appointment under the state, and that no citizen can be discriminated against or be ineligible for any employment or office under the state on the grounds given in Article 16. Article 16, clauses 1 and 2 applies only in respect of employment or office under the state. The other clauses, which are clauses 3, 4, 4a, 4b and 5, provide 4 exceptions to this general rule of equality of opportunity. The newest addition to this article is clause 6, which was introduced by the Constitution 103rd Amendment Act 2019, which provided for 10% reservation of posts for economically weaker sections of citizens in addition to the existing reservation in each category. Moving on, we will now look at the Mandal Commission. In the case of Indra Sahni versus Union of India, which is also popularly known as the Mandal Commission case, the Supreme Court dealt with various aspects of the complex issue of reservation and gave a very thoughtful judgment. Some of the key aspects of the judgment are: the majority held that a caste can be and quite often is a social class in India, and if it is backward socially, it would be backward class for the purpose of Article 16 Clause 4. Article 16 Clause 4 permits classification of backward classes into backward and more backward classes. The majority held that while identifying the backward classes, the socially advanced persons, the creamy layer among them, being excluded for the purpose of the benefit of reservation. The majority held that the maximum limit of reservation cannot exceed 50%. However, in extraordinary situations, it may be relaxed in favor of people living in remote, far-flung areas of the country. The court directed the union government, the state governments and the union territories to appoint a permanent statutory body to examine complaints of wrong inclusions or non-inclusions of groups, classes and sections in the list of other backward classes. The majority made it clear and directed that all objections to the criteria evolved by the central government and state government to exclude socially advanced persons, creamy layer, from other backward classes shall be filed only before the Supreme Court and not before any High Court or tribunal. The scenario of the post-Mandal Commission case is that Clause 4a was added in Article 16 by way of the 77th Amendment Act 1995, providing for reservations in matters of promotion, and Clause 4b was also added in Article 16 by way of the 81st Amendment Act 2000 to seek to end the 50% ceiling on reservation for SCs, STs and backward classes in backlog vacancies which could not be filled up in the previous years due to the non-availability of eligible candidates. Moving on to the next topic, we will discuss the concept of equal pay and equal work. This concept of equal pay for equal work has been developed in India through precedents. In the case of Randhir Singh versus Union of India, the Supreme Court has held that although the principle of equal pay for equal work is not expressly declared by our Constitution to be a fundamental right, but it is certainly a constitutional goal under Article 14, 16 and 39 Clause D of the Constitution. This right can therefore be enforced in cases of unequal scales of pay based on irrational classification. The decision in Randhir Singh's case has been followed in a number of cases by the Supreme Court. In the case of Federation of All India Customs and Central Excise Stenographers versus Union of India, The Supreme Court upheld the differentiation in the pay scales and ruled that although equal pay for equal work was a fundamental right, but equal pay must depend upon the nature of work done and that it could not be judged by the mere volume of work. With this, we come to an end of our discussion.